Paragraph 52 of the CCJ's decision, the written decision that it issued, states that the court also notes that an order issued by GCOM in any particular context can never determine how the Constitution is to be interpreted. It is a matter of elementary constitutional law that if ordinary legislation is in tension with the Constitution, then the courts must give precedence to the words of the Constitution and not the other way around. With respect, the notion that Order 60 could either impact interpretation of the Constitution or create a new election regime at variance with the plain words of the Constitution is constitutionally unacceptable. Counsel, the reason I've read this out is that all of today, one of the stakeholders in these election processes, one of the main stakeholders, would have used this paragraph to say that the CCJ has thrown out the importance of the recount itself, to say that the Order 60 has nothing, the CCJ has discarded the Order 60 by saying it doesn't have any importance and blah, 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 and that they're now asking that GCOM revert back to that, in my own words, fraudulent declaration of early March 2020. Is there any sanity, sir, in this presumption?
That's my director making sure I look okay. Otherwise known as my wife.
Okay, great. And I want to hello to her, sir.
Sure. Portia, hi. I think I have to be careful. But I've heard so many interpretations of the law of Guyana. And I've heard so many pronouncements as to the effect of the law of Guyana. Now I'm getting pronouncements, and I've seen some of them on the interpretation of the judgment. And a very old lawyer once said to me sometimes, when you hear conflicting opinions that are so way off what could be a fair reading of the document or the law, you need to check your library to make sure there's some other edition of the current text that may have come and changed the law. And I don't understand how anybody could have reached that conclusion. I really don't. And it's unfortunate. And what I also think was extremely unfortunate was the attempt to either influence public opinion against the CCJ or to influence the CCJ in some way with advertisements in Trinidad and with the constant statements from lawyers, some very prominent lawyers, about the decision is final and all of that. And I think that's regrettable that happened, because we have had it in the OECS a couple of times. I disliked it then, and in here in the OECS, and I sincerely dislike it, the way it was done with the CCJ, for the specific, particular, and personal reason that too often our politicians see the CCJ as a political football, as an easy target, because they won't respond. And the fact that we've had referendums in Grenada, in St. Vincent and Antigua to try to get the population on board with the CCJ, and this sort of assaults on the integrity of the CCJ are simply mind-boggling. And to do that in a referendum, one can say, well, everybody's entitled to say whatever he wants. I don't agree with that, but that's the general accepted premise. But when a matter is pending before the court of the highest constitutional importance, I would have thought the parties on both sides would have sought to exercise considerable restraint.